I'm Scott Lachlan. This is the Data Chronicles, and here are your data points. Today, we are getting an update on what is going on in India data protection law. You might recall from a prior episode that India has passed a data protection law in 2023, which will have big effects on global businesses. That law is not yet in force, but the implementation of the law now appears to be getting closer as the Indian government has published proposed rules that provide details on what the law will eventually require. These rules are still at the proposal stage, but they do provide insight into the direction of travel in India data protection law. To discuss these developments and the current state of the laws in India, I have invited Stephen Matthias to the podcast. Stephen is a partner and head of the Bangalore office at Kochar and Company and co-chair of the firm's technology law practice. Stephen was also the guest on our prior episode that covered the initial enactment of the 2023 law, and I'm so excited to have him return. Stephen, welcome to the podcast.
Great to be back, Scott.
So, Stephen, on one of our episodes, maybe it was a year or so ago, we talked about the 2023 Digital Personal Data Protection Act, which is the new law that's been adopted for privacy in India. Can you give us a sense of where that law stands? Is that currently in effect? Or have there been further developments over the past few months?
Sure. So the law was enacted by the Indian Parliament in August of 2023 and approved by the President almost immediately thereafter. But as with most Indian laws, it comes into force when it is notified by the central government. And the government has not notified the law into force yet. And so the law is still not in force. I know it's well more than 1 year since, but that's the case. The law did have provisions in it which required further delegated legislation to explain the detail. And so the government needed to prepare rules, and the government's taken a long time to prepare those rules. And so what we are discussing today, really, the draft rules that were issued very recently by the government, and those kind of explain some of the detail on implementing the new statute.
So if I'm getting it straight, the law was adopted in 2023, but it needs to go through a formal kind of publication process. And then the law itself contemplated that there will be rulemaking that would add perhaps more specificity and more detail surrounding the actual requirements referenced in the law. Is that right?
That's right. And so the draft rules now are awaiting public feedback till February 18th. And thereafter, the government will take a look at the public feedback and then, make changes and finalize the rules. And that stage, it's ready to implement the law. Then it'll, bring the law into force.
Interesting. I mean, I want to come back to the timing for all of those things in a moment, but I know when we have been talking about this law in the past, and then our clients have been considering its impact, there were a number of areas that I think clients and you were hoping that there would be further clarity and maybe a little bit more flexibility about how to comply on things like consents and notices. Maybe let's just start kind of understanding where we think the current state of play is, because even though we don't have final regulations and final rules to implement these, the proposals do indicate perhaps how the government is thinking about implementing these rules on things like consents and things like breach notification. So interested in your perspective on that, and then maybe your view as we go through these things. Is consent still the big issue here, or are you seeing other things that clients need to know about?
Yeah, I think consent is still the main issue here. Historically, we've had privacy laws which were focused on, were basically consent based. And then you had GDPR, which kind of had two different options. You had the consent option, and then you had a more principles-based approach, which is essentially legitimate interest. And the consent requirement under GDPR was just considered to be quite onerous. And so what this law has done is that it's adopted by and large the consent requirements of GDPR. So, consent has to be freely given, specific, informed, unconditional, and an unambiguous indication of consent. That's pretty much what's written in GDPR. But the difference here is that there is no concept like a legitimate interest. And our friends in the EU, most of them tell us that they use legitimate interest for the vast majority of use cases of personal information because they find the consent standard to be too high. So that high standard of consent is essentially what's been adopted here. And so we were wondering whether under this law, we might have a more reasonable, more liberalized sort of approach, or would they continue, would they essentially implement GDPR? And what we're finding here is that they are largely going to implement GDPR. So they want an itemized list of personal information being collected, the purposes for which it's collected, and the services and the goods which are being offered in relation to the personal information that's being collected. So that's pretty much a different approach to your typical legitimate interest type privacy policy and privacy notices. So I think that's really the biggest aspect of the most important aspect of this statute and the rules under it. And it does mean probably that a lot of international privacy policies and privacy notices will have to be substantially rewritten for India rather than just make your small changes here and there or have a short few paragraph addendum for specific countries. And I think that's the biggest impact of this statute.
Yeah, it's really interesting. And I just want to make sure I understand how that consent construct is going to be set up. So a few maybe more specific questions. When we're talking about consent, is that consent received from data subjects in India, or are we talking about consent for other data subjects outside of India?
So it'll be largely data subjects in India, but data subjects outside India would largely not be covered. Where what would be relevant from an international perspective is where overseas businesses located outside India are offering goods and services in India, then they would need to comply as well.
So they would get consent relating to the processing of Indian data subjects, but it wouldn't mean that if, for example, I'm a US company who has a team in India who's providing outsourced data processing services, that now we have to obtain any type of consent with respect to those US data subjects.
So there is an exemption in the case of processing of personal information in India of data subjects outside India in relation to a cross-border contract. So that would largely cover the offshoring industry. And so that concern would not arise under the statute.
Okay. But what would likely happen is for those India-based employees who are engaged in support services for multinational businesses, that those employees would need to have provided these consents. And I think one of the things that will be a challenge is that if there is no legitimate interest and the consent is the only basis for processing, then how is it that an employer can provide a consent that's, freely given or unconditional if the employee has no choice but to sign that consent?
I think that's a huge concern, the use of the word unconditional in a general sense. But in the employee area, it's less of a problem because there is an exemption for using personal information for an employment purpose. And it also covers employee benefits requested by the employee and some security practices that a typical employer would need to employ. So in those cases, there is an exemption. By and large, the statute has two kinds of exemptions. So one is an exemption entirely from the statute, and the other is an exemption from consent. But the vast majority of business usage of personal information would not be covered by those exemptions, even though in the employment arena it is.
Got it. Okay, so that will be a huge component of how we're thinking about this. Is that mean that for employment-oriented data, that there effectively is a legitimate interest kind of analysis almost where it's not if it's just all carved out from the scope of the rule, or are there specific limits on how employers may use India-based employees' data?
I think the exemption is fairly wide. In our practice, we have come across instances where the exemptions don't apply, particularly when you may be using employees for training materials, marketing materials, that sort of thing. So that's not an employment purpose. So there are some instances we've come across where the exemption doesn't apply, but by and large, it does.
Okay, that's really helpful. So the second thing that you mentioned was around notices, and that it will likely be the case that organizations who have to update all of their India-based notices, and then I think I've heard from you in the past that part of that may be not only updating the content, but also updating the language in which those notices appear.
That's right. So, because you have to have an itemized list of personal information that you're collecting, the purposes for which you're collecting it, and the goods and services for which you're using it. So, that would be largely different from most privacy policies that I have seen.
Interesting. So that means that's an additional amount. And then I think in your note, you had said there's even 22 languages that for which this needs to be updated or available.
Yeah, so the statute gives a right to an individual, a data subject, to receive the privacy notice in any one of 22 languages. So potentially a business would need to translate that into 22 languages, though in practice, especially in some areas where they have a set number of people, they could have some form of selection well in advance. And you might find that it's more three or four languages that are asked for. But there are bizarre cases where a business is offering services all over the country. They could end up having to translate into many languages.
And are these languages that are spoken in India, or are they looking to say, okay, individuals have the ability of getting a version in Portuguese or in German?
No, so India is a really multilingual country. And I don't know if there's any other country in the world which has so many different languages in different parts of the country. Literally, at least in the south, you'll find there's a different language spoken in each state. So these are all Indian languages.
Yeah, interesting. But I mean, that sounds like if we're having a notice in 22 different languages all spoken in the region, and then, starting to broaden out for global organizations to have that same notice available in many other languages around the world. Again, kind of another thing that I think clients need to be aware of as they are looking to comply with these obligations. Stephen, maybe my next kind of set of questions is around cyber. If I remember correctly, the things that you were talking about when we first met, that there was requirements around the implementation of cybersecurity controls and safeguards and obligations surrounding breach notification. What do those look like under the proposed rules?
So the statute is fairly minimalist in the sense it just requires a data controller to, implement reasonable security safeguards. But the rules have gone much further and have stated a bunch of different things. I mean, it's not like it's so unusual. So encryption, masking, control to access, ensuring there are proper logs and things like that. But what it has said is that the reasonable security safeguards must include at a minimum all of the things they prescribed. And there are about 10 different things that they prescribed. So that sounds like every single data controller or data processor will need to implement all of those. And that I think is a pretty tough thing to do. So I think in that sense, this is a very strict standard.
And these are very specific controls, encryption, using virtualization, access controls, maintenance of logs. It's not, it's much broader than saying that an organization needs to have reasonable and appropriate security.
That's right. I mean, personal information is just used in so many different functions, and so I would imagine be very hard to implement all of this in every single function, which is what literally that's what the rules seem to suggest.
And then breach notification, another area that I think many want to understand what the requirements look like. And if I'm understanding where this is headed, is that there is a breach notice rule with a very low threshold for notification.
That's right. So India already has a breach notification requirement, though that requirement is under cybersecurity laws and not under privacy laws. And that is a notification to the CERT, which has to be made within 6 hours. I have to say, in all of the notifications I've done in the last couple of years, not a single one have then been in 6 hours, and businesses have not actually been prosecuted for that. But the statute required notification to be given to both the data subject and to the DPA, which is the Data Protection Board of India, and the details to be provided in the rules. And there is no threshold, so it's not like there's some form of a risk-based threshold where you decide, okay, we cross this threshold, then we need to notify. They have to notify a data subject in every case of a data breach. Now, the rules go on to say you notify the data subject and the DPPI as soon as possible. But then it goes on to say that you will give further information to the DPPI within 72 hours. So, what that effectively means is that if there's a data breach involving personal information in India, you may have to do 4 breach notifications, one to CRT, and then the as soon as possible to the DPPI and the data subject, and then a further one to the DPPI. It's really seems like a terrible overkill.
Yeah. What are they saying about the definition of data breach? Is that
It's
a
very
defined concept?
Yeah, it's very wide, and as I said, no thresholds.
Well, all right, that will be another obligation that I think many will struggle with. Maybe another area that, as the world is rotating here, and we start to see themes cut across multiple jurisdictions, and that is around data localization and cross-border data transfer restrictions. What do the new rules and the statute provide for surrounding localization of data in India?
So India went through 5 different drafts before it finalized the statute, and during that journey, uh, the government started with a strong focus on localization, but in the final draft, they went soft on that, and they just had one provision which stated that they will come up with a blacklist of countries, and you can't transfer data at all. No method, no intergroup transfer or anything like that. No SECs to those countries. By and large, I expect those countries would be 2 types. One, countries that have a poor, low level of data protection, and the other would be countries that are perceived to be, unfriendly to India. And I mean, China, I guess, is the most obvious example there. Now, what they've done, that was a very kind of liberal approach. But what they've done in the rules is they've stated that the government can now set forth conditions and restrictions on the basis of which personal data is transferred. So that's kind of going back on the more liberal approach they adopted in the statute, and also it's questionable whether that's even legal because there's no basis for it under the statute.
Yeah, that is consistent with what we are seeing in multiple other jurisdictions, especially around the cross-border data transfers to China. And it sounds like India is no exception, that increasingly, as we deglobalize in some way, that this is now also contemplated in the India-based laws. You mentioned that in addition to those countries that may have adversarial relationships to India, that it could be countries where there's not adequate data protection laws, which is similar concept that appears in EU law. Do you give a sense that that would capture jurisdictions like the United States, which does, according to the EU, does not have adequate data protection law?
I don't think the United States or any of the major, developed countries would be covered in that blacklist.
All right. Well, that would be very helpful. And we wish the rest of the world would agree, but sadly, that's not the case. One other thing I think you asked for, you called out in your note, and then maybe want to just kind of talk about timelines for a moment, is around children. So it sounds like there are, similar to where we're seeing other laws develop globally, there are specific protections and rules surrounding children data.
So, by and large, there is a requirement for consent, verifiable parental consent. In the case of children, the age for children here is 18 years. And there are also some restrictions in terms of behavioral advertising, targeting, and so on. And while there are some, there is some liberalization in the rules, it by and large does not cover most business use cases. So we will have to look at verifiable parental consent in most cases of use of personal information of children. The good news, though, is that India does have some unique digital identification procedures, like we have one which is called Aadhaar KYC, which is somewhat SMS based, using what we call an OTP, one-time password. That's something that's very strongly prevalent in India, and a lot of regulatory procedures are using that too. So I think it'll probably be not as difficult as people expect it to be when you just read the text of the law.
Right. I think that'll be an area that I think many organizations are going to be looking for their global solutions, and it's difficult to deploy a global solution on children's data given the number of different requirements that we're seeing pop up globally, and then here in the United States, where we see many of these laws popping up, not only historically at the federal level, but now at the state level. So all of those, I think, are in the mix. And as I think about what this looks like going forward, Steve, I'm interested in your perspective on timelines, because I think you had said earlier that the comments to the rules are expected in later in February 2025, and after which time the government would consider them and then issue final rules. One, is that the right process? And then two, is do you have a sense of timing when we think we actually may have final rules and thus an effective statute in India?
Well, I expect they'll finalize the rules in the next maybe 3 or 4 months, and thereafter they should be ready to bring the statute into force and then notify the rules officially. So I expect very likely summer, or maybe July, August by then. I don't expect the government needs to go beyond that in terms of enforcing this statute. It's not clear whether they're going to give a further period for businesses to comply. I expect it to be fairly short for a couple of reasons. One is the statute has been around now for close to a year and a half. And the second is that India doesn't really have a history of giving a long time period. So I wouldn't expect more than 6 months. So very likely, all businesses will be required to comply, let's say by January of 2026.
Okay, so still a little bit of time, but not a lot of time, as you're kind of projecting forward. From your point of view, I know you work with a lot of multinational organizations on all things data and technology. What is your counsel surrounding what organizations can and should do now in preparation for what is likely to be a significant uplift for non-employee India-based consumers in India?
So I think the time is probably right now to move ahead fairly quickly. You obviously you have to start with data mapping and understanding what personal data you're using, and for what purpose, and who has the data and where it's stored. And I think that's an exercise itself which can take quite a long time, especially for less sophisticated companies that may not be complying with laws internationally. Otherwise, I think one can start the process now of preparing draft data privacy policies and notices, and analyzing to what extent the global policies of a multinational will need to be changed from an India perspective. I know for us, we've been advising clients for probably at least a year now on the applicability of the new law. Whenever a client has come to us on advice for personal on how to use personal information, we've applied both the existing law and the future law, so they have a perspective on the future law as well.
Yeah, I mean, really good advice, especially as organizations don't want to have to redo many of the things that they're doing now. Well, Stephen, I really appreciate your insights and updates on the current status of India data protection law. I'm sure we'll have a chance to, sounds like, talk again soon as we actually get a finalized law with a specific compliance date in mind. And at that point, I'd love to have you back on and we can talk about how to comply.
Sure. Always good chatting with you, Scott.
Excellent. Well, with that, I'm Scott Lachlan. This is the Data Chronicles, and those were your data points.